Section 48. Mode of settlement of accounts between partners. In settling the accounts of a firm after dissolution, the following rules shall, subject to agreement by the partners, be observed. Subsection A. Losses, including deficiencies of capital, shall be paid first out of profits, next out of capital, and, lastly, if necessary, by the partners individually in the proportions in which they were entitled to share profits. Subsection B. The assets of the firm, including any sums contributed by the partners to make up deficiencies of capital, shall be applied in the following manner and order. Clause I. In paying the debts of the firm to third parties. Clause E. In paying to each partner ratably what is due to him from the firm for advances as distinguished from capital. Clause E. In paying to each partner ratably what is due to him on account of capital. And Clause IV. The residue, if any, shall be divided among the partners in the proportions in which they were entitled to share profits. 49. Section 49. Payment of firm debts and of separate debts, where there are joint debts due from the firm, and also separate debts due from any partner, the property of the firm shall be applied in the first instance in payment of the debts of the firm, and, if there is any surplus, then the share of each partner shall be applied in payment of his separate debts or paid to him. The separate property of any partner shall be applied first in the payment of his separate debts, and the surplus, if any, in the payment of the debts of the firm. Section 50. Personal profits earned after dissolution, subject to contract between the partners. The provisions of Clause A of Section 16 shall apply to transactions by any surviving partner or by the representatives of a deceased partner, undertaken after the firm is dissolved on account of the death of a partner and before its affairs have been completely wound up. Provided that where any partner or his representative has bought the goodwill of the firm, nothing in this section shall affect his right to use the firm name. Section 51. Return of premium on premature dissolution, where a partner has paid a premium on entering into partnership for a fixed term, and the firm is dissolved before the expiration of that term otherwise than by the death of a partner, he shall be entitled to repayment of the premium or of such part thereof as may be reasonable, regard being had to the terms upon which he became a partner and to the length of time during which he was a partner, unless subsection A. The dissolution is mainly due to his own misconduct, or subsection B. The dissolution is in pursuance of an agreement containing no provision for the return of the premium or any part of it. Section 52. Rights where partnership contract is rescinded for fraud or misrepresentation, where a contract creating partnership is rescinded on the ground of the fraud or misrepresentation of any of the parties thereto, the party entitled to rescind is, without prejudice to any other right, entitled. Subsection A. To a lion on, or a right of retention of, the surplus or the assets of the firm remaining after the debts of the firm have been paid, for any sum paid by him for the purchase of a share in the firm and for any capital contributed by him. Subsection B. To rank as a creditor of the firm in respect of any payment made by him towards the debts of the firm, and Section 53. Right to restrain from use of firm name or firm property. After a firm is dissolved, every partner or his representative may, in the absence of a contract between the partners to the contrary, restrain any other partner or his representative from carrying on a similar business in the firm name or from using any of the property of the firm for his own benefit, until the affairs of the firm have been completely wound up. Provided that where any partner or his representative has bought the goodwill of the firm, nothing in this section shall affect his right to use the firm name. Section 54. Agreement in restraint of trade. Partners may, upon or in anticipation of the dissolution of the firm, make an agreement that some or all of them will not carry on a business similar to that of the firm within a specified period or within specified local limits, and notwithstanding anything contained in Section 27 of the Contract Act, 1872, such agreement shall be valid if the restrictions imposed are reasonable. Section 55. Sale of goodwill after dissolution. 1. In settling the accounts of a firm after dissolution, the goodwill shall, subject to contract between the partners, be included in the assets, and it may be sold either separately or along with other property of the firm. 2. Where the goodwill of a firm is sold after dissolution, a partner may carry on a business competing with that of the buyer and he may advertise such business, but, subject to agreement between him and the buyer, he may not a. Use the firm name. B. Represent himself as carrying on the business of the firm, or C. Solicit the custom of persons who were dealing with the firm before its dissolution. 3. Any partner may, upon the sale of the goodwill of a firm, make an agreement with the buyer that such partner will not carry on any business similar to that of the firm within a specified period or within specified local limits, and, notwithstanding anything contained in Section 27 of the Contract Act, 1872, such agreement shall be valid if the restrictions imposed are reasonable. Chapter 7 Registration of Firms. Section 56. Power to exempt from application of this chapter. Provincial government of any province may, by notification in the official gazette, direct that the provisions of this chapter shall not apply to that province or to any part thereof specified in the notification. Section 57. Appointment of registrars. 1. The provincial government may appoint registrars of firms for the purposes of this Act, and may define the areas within which they shall exercise their powers and perform their duties. 2. Every registrar shall be deemed to be a public servant of within the meaning of Section 21 of the Pakistan Penal Code. Section 58. Application for registration. 1. The registration of a firm may be effected at any time by sending by post or delivering to the registrar of the area in which any place of business of the firm is situated or proposed to be situated, a statement in the prescribed form and accompanied by the prescribed fee, stating a. The firm name. b. The place or principal place of business of the firm. c. The names of any other places where the firm carries on business. d. The date when each partner joined the firm. a. The names in full and permanent addresses of the partners, and f. The duration of the firm. The statement shall be signed by all the partners, or by their agents specially authorized in this behalf. 2. Each person signing the statement shall also verify it in the manner prescribed. 3. A firm name shall not contain any of the following words, namely: government, emperor, empress, empire, imperial, king, queen, royal, jinnah, Quaid-i-Azam, dominion, or words expressing or implying the sanction, approval or patronage of the government or of the Quaid-i-Azam or the central government or any provincial government, except when the provincial government signifies its consent to the use of such words as part of the firm name by order in writing. 3a. A firm name shall not contain the name of the United Nations, or its abbreviations through the use of its initial letters or of any subsidiary body set up by that body unless it has obtained the previous authorization of the Secretary General of the United Nations in writing. 3b. A firm name shall not contain the name of the World Health Organization, or its abbreviations through the use of its initial letters unless it has obtained the previous authorization of the Director General in writing. Section 59. Registration. When the registrar is satisfied that the provisions of Section 58 have been duly complied with, he shall record an entry of the statement in a register called the Register of Firms, and shall file the statement. Section 60. Recording of alteration in firm name and principal place of business. 1. When an alteration is made in the firm name or in the location of the principal place of business of a registered firm, a statement may be sent to the registrar accompanied by the prescribed fee, specifying the alteration, and signed and verified in the manner required under Section 58. 2. When the registrar is satisfied that the provisions of subsection 1 have been duly complied with, he shall amend the entry relating to the firm in the Register of Firms in accordance with the statement, and shall file it along with the statement relating to the firm filed under Section 59. Section 61. Noting of closing and opening of branches. When a registered firm discontinues business at any place or begins to carry on business at any place, such place not being its principal place of business, any partner or agent of the firm may send intimation thereof to the registrar, who shall make a note of such intimation in the entry relating to the firm in the Register of Firms, and shall file the intimation along with the statement relating to the firm filed under Section 59. Section 62. Noting of changes in name and addresses of partners. When any partner in a registered firm alters his name or permanent address, an intimation of the alteration may be sent by any partner or agent of the firm to the registrar, who shall deal with it in the manner provided in Section 61. Section 63. Recording of changes in and dissolution of a firm. 1. When a change occurs in the constitution of a registered firm, any incoming, continuing or outgoing partner, and when a registered firm is dissolved, any person who was a partner immediately before the dissolution, or the agent of any such partner or person specially authorized in this behalf, may give notice to the registrar of such change or dissolution, specifying the date thereof, and the registrar shall make a record of the notice in the entry relating to the firm in the Register of Firms, and shall file the notice along with the statement relating to the firm filed under Section 59. 2. When a minor who has been admitted to the benefits of partnership in a firm attains majority and elects to become or not to become a partner, and the firm is then a registered firm, he, or his agent specially authorized in this behalf, may give notice to the registrar that he has or has not become a partner, and the registrar shall deal with the notice in the manner provided in subsection 1. Section 64. Rectification of mistakes. 1. The registrar shall have power at all times to rectify any mistake in order to bring the entry in the Register of Firms relating to any firm into conformity with the documents relating to that firm filed under this chapter. 2. On application made by all the parties who have signed any document relating to a firm filed under this chapter, the registrar may rectify any mistake in such document or in the record or note thereof made in the Register of Firms. Section 65. Amendment of register by order of court. A court deciding any matter relating to a registered firm may direct that the registrar shall make any amendment in the entry in the register of firms relating to such firm which is consequential upon its decision, and the registrar shall amend the entry accordingly. Section 66. Inspection of register and filed documents. 1. The register of firms shall be open to inspection by any person on payment of such fee as may be prescribed. 2. All statements, notices and intimations filed under this chapter shall be open to inspection, subject to such conditions and on payment of such fee as may be prescribed. Section 68. Rules of evidence. 1. Any statement, intimation or notice recorded or noted in the register of firms shall, as against any person by whom or on whose behalf such statement, intimation or notice was signed, be conclusive proof of any fact therein stated. 2. A certified copy of an entry relating to a firm in the register of firms may be produced in proof of the fact of the registration of such firm, and of the contents of any statement, intimation or notice recorded or noted therein. Section 69. Effect of non-registration. 1. No suit to enforce a right arising from a contract or conferred by this Act shall be instituted in any court by or on behalf of any person suing as a partner in a firm against the firm or any person alleged to be or to have been a partner in the firm unless the firm is registered and the person suing is or has been shown in the register of firms as a partner in the firm. 2. No suit to enforce a right arising from a contract shall be instituted in any court by or on behalf of a firm against any third party unless the firm is registered and the persons suing are or have been shown in the register of firms as partners in the firm. 3. The provisions of subsections 1 and 2 shall apply also to a claim of set-off or other proceeding to enforce a right arising from a contract, but shall not affect the enforcement of any right to sue for the dissolution of a firm or for accounts of a dissolved firm, or any right or power to realize the property of a dissolved firm, or b. the powers of an official assignee, receiver or court under the Insolvency, Karachi Division and Dakcha Act, or the Provincial Insolvency Act, 1920 to realize the property of an insolvent partner. 4. This section shall not apply to firms or to partners in firms which have no place of business, Pakistan, or whose places of business, Pakistan, are situated in areas to which, by notification under Section 56, this chapter does not apply, or b. to any suit or claim of set-off not exceeding 100 rupees in value which is not of a kind specified in the second schedule to the Provincial Small Cause Courts Act, 1887, or to any proceeding in execution or other proceeding incidental to or arising from any such suit or claim. Section 70. Penalty for furnishing false particulars. Any person who signs any statement, amending statement, notice or intimation under this chapter containing any particular which he knows to be false or does not believe to be true, or containing particulars which he knows to be incomplete or does not believe to be complete, shall be punishable with imprisonment which may extend to 3 months, or with fine, or with both. Section 71. Power to make rules. 1. The provincial government may make rules prescribing the fees which shall accompany documents sent to the registrar of firms, or which shall be payable for the inspection of documents in the custody of the registrar of firms, or for copies from the register of firms, provided that such fees shall not exceed the maximum fees specified in Schedule 1. 2. The provincial government may also make rules prescribing the form of statement submitted under Section 58, and of the verification thereof. b. Requiring statements, intimations and notices under Sections 60, 61, 62 and 63 to be in prescribed form, and prescribing the form thereof. c. Prescribing the form of the register of firms, and the mode in which entries relating to firms are to be made therein, and the mode in which such entries are to be amended or notes made therein. d. Regulating the procedure of the registrar when disputes arise. a. Regulating the filing of documents received by the registrar. f. Prescribing conditions for the inspection of original documents. g. Regulating the grant of copies. h. Regulating the elimination of registers and documents. I. Providing for the maintenance and form of an index to the register of firms, and j. Generally, to carry out the purposes of this chapter. 3. All rules made under this section shall be subject to the condition of previous publication. Chapter 8. Supplemental. 72. Mode of giving public notice. A public notice under this Act is given where it relates to the retirement or expulsion of a partner from a registered firm, or to the dissolution of a registered firm, or to the election to become or not to become a partner in a registered firm by a person attaining majority who was admitted as a minor to the benefits of partnership, by notice to the registrar of firms under Section 63, and by publication in the official gazette, and in at least one vernacular newspaper circulating in the district where the firm to which it relates has its place or principal place of business, and b. in any other case, by publication in the official gazette, and in at least one vernacular newspaper circulating in the district where the firm to which it relates has its place or principal place of business. Section 73. Repeals. Representative by the Repealing Act, 1938, 1 of 1938, Section 2 and Schedule. Section 74. Nothing in this Act or any repeal affected thereby shall savings affect or be deemed to affect a. Any right, title, interest, obligation or liability already acquired, accrued or incurred before the commencement of this Act, or b. any legal proceeding or remedy in respect of any such right, title, interest, obligation or liability, or anything done or suffered before the commencement of this Act, or c. anything done or suffered before the commencement of this Act, or d. any enactment relating to partnership not expressly repealed by this Act, or a. any rule of insolvency relating to partnership, or f. any rule of law not inconsistent with this Act.